Welcome to Hall and Estates and Succession Planning, a series of podcasts hosted by Ian Hall and Suzana Popovic-Montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull & Hull in Toronto, here are Ian and Suzana.
Hi, and welcome to Hull on Estate and Succession Planning. You're listening to episode 193 of our podcast on Tuesday, February 2nd, 2010.
Hi, Suzana.
Hi there, Ian.
So welcome.
Thank you.
And now that we're back full speed, we want to dive right into our topic today.
Yes.
We want to take no prisoners because we've got lots we want to talk about, and some of the interesting developments as well in the social media world that if we have time at the end we'll discuss as well. But let's turn away from, we talked about getting paid in guardianship when we last were talking about legal-based podcasting, and now let's talk a little bit about the guardianship process more generally.
And when we talk about the guardianship process, Ian, we're talking about the situation where someone doesn't have a power of attorney, or they have a power of attorney that's only for limited purposes or for limited assets. And so in this case, you need the assistance of the court to give you the authority to deal with someone's assets if they haven't provided for that while they were capable themselves.
For sure, and that whole question of what do you do if there is no power of attorney is dealt with across the U.S. and in Canada in different pieces of legislation. Ours, of course, is Substitute Decisions Act, but they all typically do the same thing, and that is they break down the role into two or three parts. That is, of course, a guardianship for property, we call it in Ontario, guardianship for personal care, and some jurisdictions, and Ontario touches on it, is the whole question of a living will, and what role, if any, the court can play in that. So let's break it down now. We're dealing with guardianships of property at the outset. That's a good starting point. The first step along the way is what? When we're going to go to the court and get appointed as guardian for property.
Well, basically we're talking about a court proceeding, and so we're going to need a notice of application that seeks that appointment. We're going to need the proposed guardian's affidavit in support of that application, and as part and parcel of that, a management plan that sets out how it is that the proposed guardian wants to or will deal with the incapable person's assets.
And the key component of all the documents that are before the court is, of course, the finding of incapacity, the doctor's certificate certifying that the individual is incapable.
And I think we can't underestimate the importance of that finding, because the first thing that in our experience a judge will look for is that statement in the affidavit that says Dr. So-and-so has found this person to be incapable of managing property. And that is really the crucial the crucial point for any kind of application where you're trying to get control over someone else's assets.
All right, so when we deal with, and we've talked about in previous podcasts, so I don't want to get into too much detail on, and this podcast anyway, on the duties and roles of a guardian for property, because we've kind of hashed those out over the time, but let's focus on the guardianship of personal care. And first of all, again, similar materials, of course, are filed. You need a plan. A management plan is for the guardianship for property. A guardianship plan is for guardianship for personal care. You need you need to tell the court how you intend to behave, and you need to have a finding of incapacity. Again, the doctor's finding of incapacity. So with those in mind, the similarities are obvious in that sense. What are some of the goals or duties or roles of the power of attorney for personal care now?
Well, when it comes to personal care, it's really broken down into a number of different categories. And so you can have a finding on someone being incapable of all of the categories, on some of them or most of them, and it can really be quite flexible. And when I talk about categories, I'm talking about things like health care, like nutrition, like shelter, like clothing, being capable of taking care of one's hygiene and safety. And those are the kinds of big headings that we're going to look at when we're looking at a guardianship plan and how someone proposes to deal with someone on each of those bases.
All right, and again, sort of keeping in the back of the mind, of course, the court's ongoing obligation for ensuring that everything that is done in the best interests of the incapable.
And our legislation, certainly here in Ontario, talks to that being one of the requirements, that and consulting with the incapable person to the extent that you possibly can, making them informed of what it is that you're doing, and also consulting with supportive family members, so that really it is like a family kind of management, a family kind of care for the individual to the extent that that's possible.
Well, and that consistency is so very important when we're dealing with the personal care decisions, and ideas such as you can get into some unnecessary tension when you have to, for example, picking caregivers. And that tension can be alleviated substantially if you have good cooperation and coordination, but also good communication.
You know, I think we talked on a previous podcast about the importance of documenting the work that you do. And we said previously also that, you know, when you're dealing with someone in a rush or a crisis situation, sometimes keeping notes of what it is that you're doing just is the last thing from your mind. And I'd say it's maybe even differently, but maybe more so in this situation when you're dealing with someone's well-being, their personal care. Those decisions have to sometimes be made quickly. They have to be made without the benefit of being able to do a whole bunch of thinking in advance. It's maybe just a reactionary kind of decision, and to be able to document that is something that we do try to tell people to keep in mind, because at the end of the day you're going to have to explain it to someone possibly, and you want to be able to remember, to reconstruct why it was that you did what you did at that time.
For sure. You know, keeping copies of all relevant documentation that you make, that others make, doctor's notes, doctor's reports, anything like that. Keeping handy the power of attorney documents. I had a client yesterday call and say they're quite healthy, but they said that we've been looking through our files and we can't find our power of attorney. And so, you know, those are important documents to maintain, but if they were incapable, it could be a really difficult scenario. So you're right, record keeping and keeping all of these significant decision-making documents that identify the decisions and why and how is vital. All right. One of the things too, when you take on the role of guardian of personal care and properties of the same circumstances in some respects, is of course access to those documents. So if you don't have them in hand, is it worth getting it in hand? Because we talked about in a previous podcast the right of a power of attorney for property to go and look at the will to make sure that he or she isn't conducting the business affairs of the individual in complete absence of the will provisions. And I think it's very important as well for personal care that they go out and seek out the medical records to the extent that they're relevant and necessary to help you better understand what personal care decisions you need to make. If you don't know the nature of the illness or the kinds of symptoms that the individual is suffering from, and that you could glean them from looking at medical reports and so forth, or records of some relatively consistent period of time that is fairly current, it can go a long way to assisting you. It's a bit of an intrusion into the person's life, but the point is that you're here to help. And if you're here to help, access to that medical information can be vital.
And just from a planning perspective too, I know many times when people will create their wills and they create their powers of attorney at the same time, to have documents and know where those documents are. And so maybe we don't have a power of attorney, for instance, here, but we might have some direction, some note that says, you know, if and when something were to happen, this is something that's important to me. So having that in the right hands, or even telling people where to look for it at the end of the day, is something that, to the extent we can try to get people to think about in advance, I think is very helpful.
Terrific. All right, well, let's continue this discussion on, but we're at our treadmill time. So we want to thank everyone and welcome everyone back to our regular podcast from our brief reprieve that we discussed at our last podcast. And thank you very much for today.
Thanks, Ian.
You have been listening to Hall on Estates and Succession Planning by Ian Hall and Suzana Popovic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.